Today inside the Senate Judiciary Committee, Senator John Kennedy delivered what can only be described as a bar exam on live television. A federal judicial nominee faced rapid-fire questions, revealing shocking gaps in knowledge. This is part one of the exchange, a must-watch for anyone who cares about our courts. Senator Kennedy leaned forward and asked about the Dormant Commerce Clause. The nominee hesitated, clearly uncertain. The senator pressed, "Were you reversed in that case?" The nominee fumbled through partial recollections. It set the tone. This was not going to end well.
Tell me what Article 5 of the Constitution does.
Article 5 is not coming to mind at the moment.
Okay. How about Article 2?
Neither is Article 2.
Judge Cruz, you handled a case called ViaNet Operating Group v. Maurice. Is that right?
That's correct, Senator.
And you were reversed in that case. Is that right?
Yes, Senator.
You remember a case called Yentzer v. Potter County?
I don't know if I recall the details of it.
The higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Tell me about the Dormant Commerce Clause.
Senator, I'm somewhat familiar with the Commerce Clause, which is found in Article 1 of the Constitution.
It was a big Supreme Court case. It just came out of your state.
And I apologize, Senator. In my 11 years of practice and my 5 years on the bench, I have not dealt with the Dormant Commerce Clause.
Do you remember a case called Janney v. Gomez?
Yes, Senator.
And were you reversed in that case?
A portion of that was reversed as well, Senator.
Okay. Do you know what purposivism is?
In my 12 years as an assistant attorney general and my 9 years serving as a judge, I was not faced with that precise question.
A question on purposivism, a key legal principle, was met with hesitation. The nominee, despite years of practice, admitted never facing the concept directly. Watching this unfold was jaw-dropping. For a federal bench nominee, failing to explain this method raised real questions. Don't miss more. Subscribe for Capitol Conservatives' unfiltered Capitol Hill coverage.
How about a case, do you remember this case, Judge Schwartz v. City of Denver?
The name is familiar, Senator. For all the cases I've handled, I'm not recalling particulars about that case.
Okay. Do you remember being reversed in that case?
Senator, I'm not specifically recalling that case.
Ms. Hill, what is collateral estoppel?
Collateral estoppel. I certainly do know collateral estoppel. I'm finding that the bright lights of the moment are making it hard for me to recall it.
Okay, so you don't recall it. Okay. Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
The district court declined to adopt the report and
The
recommendation.
higher court said you were wrong.
The district court disagreed with my report, yes.
Yeah, okay. Judge Hugh, tell me about New York Times v. Sullivan.
I believe that was a First Amendment case, Your Honor. I'm sorry, Senator, about free speech. But in my 5 years of being a judge and 25 years of practice, I haven't had to actually apply New York Times v. Sullivan.
Kennedy didn't let up. He asked, "What is collateral estoppel?" The nominee admitted the pressure made it hard to recall. Kennedy then mentioned Dennis versus Sheridan, another reversal on the nominee's record. Again, the answers fell flat, one stumble after another. The defining moment came when Senator Kennedy asked, "Tell me how you analyze a Brady motion." Silent. Nominee didn't know. Kennedy pressed, "Do you know what a Brady motion is? Do you recall Brady versus Maryland?" The nominee thought it was about the Second Amendment. Kennedy reminded everyone, "This is not a small question. For a judicial nominee to miss Brady versus Maryland is a deal-ender."
Tell me how you analyze a Brady motion.
How I analyze a Brady motion?
Yes.
Senator, in my 4.5 years on the bench, don't believe I've had the occasion to address a Brady motion in my career.
Do you know what a Brady motion is?
Senator, in my time on the bench, I've not had occasion to address that, and so it's not coming to mind at the moment what a Brady motion is.
Do you recall the U.S. Supreme Court case Brady v. Maryland?
I do recall the name of the case, Senator, yes.
And what did it hold?
I believe that the Brady case involved, Senator, I believe the Brady case involved something regarding the Second Amendment. It is not, I've not had occasion to address that. If that issue were to come before me, I would certainly analyze that Supreme Court precedent.
What is the difference between a stay order and an injunction?
A stay order would prohibit, an injunction would restrain the parties from taking action. A stay order, I'm not sure that I actually can give you that.
The final exchange focused on the difference between a stay order and an injunction. The nominee's response was muddled, making the hearing feel more like an oral exam gone wrong. Kennedy's questions exposed weaknesses that experience alone couldn't hide. The future of our courts depends on it. Today showed just how high the stakes are for lifetime judicial appointments. Senator Kennedy's bar exam exposed a nominee unprepared for the bench. Stay tuned to Capitol Conservatives for Part 2, and don't forget to subscribe for updates.